That's no problem. Can I have the clerk present, please?
Hey, sir, I'm Magistrate in Chartea. DDC.
Excuse me? Yeah.
I'm talking to the DDC officer.
Yes.
DDC?
Yes, ma'am.
Okay. The gentleman that is in front of the screen, in front of camera 1, what name do you have him listed as?
Kevin Pollard.
Do you have a middle name?
No, ma'am.
Okay, so you have a Kevin Pollard. Okay, and sir, you're identified as Kevin Pollard, but you're considering yourself the beneficiary. Is that correct, sir?
Are we on the record?
We are. Everything is on the record.
Okay, are you stating that the trust that we are now administrating is the Kevin Pollard trust, ma'am?
I'm not administrating any trust because there is no trust in front of me. But what I'm asking you is, you call yourself the beneficiary. Is that correct?
Yes, Your Honor.
Okay, no problem. I have case number is 240-5538101. People of the state of Michigan versus Kevin Theron Anthony Pollard.
You are under oath and you are on record. And I'm asking you,
beneficiary, I have not sworn you under oath. I am under oath, so I am doing all this. I'm going to enter plea of not guilty. I already given the court dates while this case is pending, sir. Okay, there should be no contact with the individual.
You are not allowed to state what the judgment is. That is my job.
Mr. Pollard, I do want to let you know that the judgment.
Okay.
I have a question for the clerk.
Okay.
I have a question for the clerk. I have a question for the clerk.
You will give an opportunity, sir. You will give an opportunity. Let me finish. The people, go ahead, Esteban.
Yeah, the people are asking for $250,000 cash bond, no cash, no surety. If he's able to ever post bond, we'd like GPS tether with home arrest. The defendant, Your Honor, has a continuing situation where he entices young girls on the internet from Arizona in this particular case, and previously on 10/23/2023 in another case where he enticed people. He's been arrested 3 different times for criminal sexual conduct. The first case, he was found not guilty back on 5/15/2015. The 10/21/2023 case, where he was criminal sexual conduct 1st degree and also contributing alcohol to a minor, 2 counts of that, was at the exam dismissed without prejudice. In our particular case we have here today, Your Honor, the victim is from Arizona. She came here after having a relationship, not the victim, but one of the witnesses came here after having a 3-year relationship with this defendant on the internet. When she turned 18, she came to visit. And also, Mr. Pollard introduced her to another girl who is also...
Before we even press play, let me warn you, this is not your typical sovereign citizen argues about a driver's license situation. This one spirals fast. We're heading to Michigan, where a defendant refuses to acknowledge his own name, claims to be the beneficiary of a mysterious trust, and at one point actually tells the judge that the judge is the one being charged. Yes, that UT dark turn. Because once the prosecutor begins laying out the allegations, the entire tone shifts from bizarre to deeply disturbing. We're not just dealing with delusion or courtroom theatrics. We're dealing with serious criminal accusations involving see closely how the magistrates handle the disruption. Watch how the attorney tries to regain control. And most importantly, watch what happens when ideology collides with reality, especially when a $250,000 cap.
The person was tired from traveling. She fell asleep in the living room. When she woke up, she went into the bedroom, and there was Mr. Pollard with the 7-year-old girl. He then said, "What are you doing?" And he says, "Well, we're playing video games." So the woman, the adult in the room, she falls asleep again. And then she is awakened by the 7-year-old girl and asked to leave. The 7-year-old girl then tells her mother that Mr. Pollard touched her, rubbed her, he says, okay? He said, accidentally is what he's trying to tell us what happened. Connor, the situation is she's told the 7-year-old child has told TED Talk that he did this. He's told Protective Services that he did this. And as far as I'm concerned, Judge, he fits the category of a predator because he did the same thing in the 10/23/2023 case of enticing young people from other parts of the country, perhaps, I don't know where exactly, to come and see him on the internet. So we're asking for $250,000 cash bond, no surety, and no. And
this is textbook sovereign citizen doctrine in motion. Notice how he refuses to give a direct answer. Instead of stating his name, he reframes himself as the beneficiary. This is rooted in the so-called strawman theory, the belief that the government created a legal entity tied to your birth certificate, and that by separating yourself from it, you can avoid criminal liability. It sounds complex. It sounds official. But legally, it carries zero weight in watch the magistrate's patience. He doesn't debate philosophy. He doesn't entertain the theory. He keeps asking the same simple question. What's your name? That's how courts maintain control, clarity, repetition, and record accuracy. Already you can feel the tension building. He thinks he's running a strategy. The court is just trying to get through an arraignment.
10% bond if this court is not inclined to do a high personal bond. So one, I know the bulk of Brother Counsel's argument was this dismissed case from last year. I'd ask that this court sentence him based on these allegations and the facts and details surrounding this case. This is a 2020 case. And the woman that he met was 20 years old, or that came to see him was a 20-year-old woman, was not an underage woman. And the allegation is that she brought her, I believe, goddaughter to the home. Now, there are different variations because a couple different stories are told as to what occurred there. But Mr. Pollard has maintained that he did not sexually assault the little girl. I'm not sure why this case wasn't charged until 2024, but it is a 4-year-old case. My understanding is that he, I don't believe he's had any convictions.
This particular matter in reference to the beneficiary who is listed by the court or by DDC as Kevin Pollard is that in this particular matter, even though this is from 2020, okay, there was a forensic interview, Kids Talk, with the victim, and she disclosed that she was touched by the defendant and that he rubbed her with his hand. This court is not considering the other cases that were dismissed without prejudice. Okay, this court is only going with this matter. In reference to this gentleman, the defendant, bond is going to be $250,000 cash. There's going to be a GPS tether, home arrest. Further, okay, it's going to be unaffordable. So today is Friday. He's going to get another court date. Today is the 26th. January 29th, 2024, 9 o'clock in front of Judge McConicle, who's going to be looking at the bond amount and bond conditions. Also, there is one other thing. This court looks at clear and convincing evidence standard, okay, based on the representation, based on the reading. This court is convinced that Mr. Pollard, okay, I'm sorry, the beneficiary, okay, that he is a predator in this particular matter. That's why we're putting at $250,000 cash, GPS tether, house arrest. He does have the unaffordable bond redetermination for this Monday, January 29th, 2024, 9 o'clock in front of Judge McConicle. Also, there's another bond condition. He's not to be around any minor children. That concludes the arraignment of the beneficiary, also known as Kevin Pollard. Madam Clerk.
Pretrial,
Do you wish
No, I was
to talk to the gentleman that's in front of the screen?
Judge.
Okay. Just so for the record, is that the clerk has declined to talk to the gentleman in front of the screen.
And there it is, escalation. Up until now, he was refusing identity. But now, he flips it entirely. He tells the judge that the judge is the defendant. This is the moment where sovereign ideology moves from evasive to surreal. In his framework, he believes he can redirect legal responsibility simply by declaring someone else the trustee. Here's the problem. Courts operate on records, not wordplay. Jurisdiction isn't reassigned because you say so. And notice how the judge responds. No yelling, no debate, just a clean procedural move. That's experience. The court doesn't get dragged into absurdity. It keeps the rails steady while the defendant veers off his point. You have to ask, does he truly believe this works? Or is this calculated?
My client's 38 years of age. He's on Social Security disability, Judge. I don't see any criminal history for Mr. Pollard, Your Honor. He lives in the city, does have a child. Your Honor, this alleged incident occurred back in 2020. So it's some 4 years ago. Obviously, it's a serious case, obviously. But it's 4 years old, Judge. He has no priors. I'm asking respectfully for a reduction in bond. The bond is $250,000 cash. Judge, I know the court will impose a GPS tether. I already know that, Judge. My client, in fact, Judge, he has a tether already on. He has a tether already on. Let me be clear about that. There's a misdemeanor, and I apologize, Judge, if I said something wrong initially. There's a misdemeanor that he has the tether for, so it's a misdemeanor.
Okay.
Your Honor. And he does a lawn care service, so he does have some work that he does, but the court doesn't have to worry about tether. I'm just asking for a reduction in bond to either a high some type of 10% bond. I think 250,000, Judge, is excessive. Thank you.
Okay. Mr. Prosecutor.
Judge, the defendant on the screen today in the top left, he's being charged with sexually assaulting a 7-year-old. The assault allegedly happened at his house in his bed. Your Honor, this is an individual who allegedly is self-proclaimed, gave the magistrate such a hard time that multiple magistrates actually ended up having to handle the matter because he wouldn't give up his name or his identity. Now, being charged with this and now knowing what his past is like, I may refrain from giving a magistrate or a judge my name as well. Because, Judge, the situation that Mr. Reagan is talking about that the defendant's involved in right now, it has to do with selling and furnishing alcohol to minors, to a 12-year-old and 14-year-old. It actually originally began as a criminal sexual conduct first degree where the defendant allegedly was having sex with the 12-year-old. But Your Honor, based on apparently the idea that somebody didn't appear at a hearing, it was reduced to the selling and furnishing of the alcohol. So he has an ongoing matter right now, Judge. He's on bond. We have this particular matter, allegedly, where this individual ended up touching a 7-year-old's vagina. We have corroboration to that, Judge. And Your Honor, with all due respect, the way that the people see this defendant based on—
The magistrate uses the phrase timeout in a criminal proceeding. You know the patience meter is running low. But here's what's interesting. Instead of escalating tension, the judge actually diffuses it. He doesn't argue with him. He doesn't threaten him. He simply pauses the disruption. That's courtroom control at its simplest fact. That it takes 2 magistrates to push this arraignment forward tells you something important. The defendant's strategy isn't about clarity. It's about delay. Sovereign tactics often rely on confusion and repetition. But watch what happens next, because the second magistrate uses a subtle, very smart workaround that completely bypasses the ideological trap. This is where procedure quiet.
See, where we I haven't heard their arguments of counsel. Where this gets a little dicey for concerning bond is that we have a situation where the defendant allegedly, I guess, an 18-year-old comes in town to visit with him for her birthday. She turned 18, so she comes to see the 37-year-old who she's been in a long-term relationship with for the last 3 years. So I guess he would have been 34 starting the relationship with the 15-year-old. Allegedly, she talks to a friend and they come over and the 7-year-old is over. The girl comes and finds the 2 of them in the bed, and then the mother contacts a person asking who is this Kevin guy, because Her daughter says he touched her vagina. So, and then we have another case of furnishing alcohol to 12-year-olds, and whether there's sex there or not sex there, we have a pattern that's it's a little bit concerning. It's a lot of minors, a lot of alcohol, a lot of sex allegations, a lot of molestation allegations, a lot of flying people in who are kids and teenagers, and so yeah, we're real concerned about this. So the $250,000 bond is an unaffordable bond, and so the court does find that this defendant is a danger to all kids. He's just a danger. The court is going to disagree with the magistrate on this, and I know the magistrate or magistrates had some issues with this defendant, and they used the information that they had at this time to come up with the $250,000 bond. But the court does find that Mr. Pollard poses a great danger to the community, and a $250,000 bond is unaffordable, but it's not enough. It's not enough. So what we're going to do is we're going to add some to it to make sure he's incapacitated. But if he posts the bond, then that means we know that he'll appear for court. So the bond is going to be increased to $1 million. Got him. And that'll be $1 million cash. If he makes the $1 million, then he'll be placed under house arrest with GPS tether. Mr. Pollard is not to have any interactions with anyone under the age of 18, whether they're family, whether he knows them. He's not to be around anyone under the age of 18. If he is, that will violate this bond. Thank you.
So Judge, the bond was 250,000 cash.
Yeah, and then now it's $1 million cash. Now it's $1 million cash.
Okay.
It's $1 million now. It's $1 million now.
Okay, because he's on Social Security disability now. Can't afford it.
I understand, but the court finds that Mr. Pollard, it may be some serial action is going on right here, and I don't really know if he's like a serial rapist. I don't know if there are other children that he just lays in the bed with allegedly and touches, or there's other 12-year-olds, or if he's flying other 18-year-olds out to celebrate their birthday. I'm not sure. So what we have to do is we're going to err on the side of caution and make sure that Mr. Pollard is not able, at least right now, to be able to engage or even be charged with engaging in these type of activities.
Now everything changes. Up to this point, you might have been tempted to see this as chaotic courtroom TR. But the second the prosecutor begins outlining the allegations, the mood shifts completely. Multiple prior arrests, internet relationships, a 7-year-old child, a forensic interview. This is no longer abstract legal carefully to how the prosecutor builds a pattern. Not just a single allegation, but BHAT allegedly repeats. That matters at bond hearings. Because bond isn't about guilt, it's about risk.